let's go over what is an anti-SLAPP motion. Now, anti-SLAPP motions are really amazing for throwing cases out because somebody exercised their First Amendment protected activities and got sued over it. So the first big question that's asked is, am I being sued over something that is protected under the Constitution and the First Amendment? The way to define it is not simple. So I could show you some anti-SLAPP motions, but they're very lengthy. So we first start with this. You've been sued. You're the defendant, and they're suing you for false light. You put them in a false light. They're suing you for defamation, which could include slander. Remember, the essence slander means spoken, or libel, which is something that's written typically. Something you said, something you wrote. You're looking at this lawsuit and you're thinking, I need to call a lawyer because there's no way you can do an anti-SLAPP motion by yourself. Now remember, if you win the anti-SLAPP motion, which is a motion that says what I said was protected by the First Amendment, if it interferes on my rights to petition government, whatever, and you can't sue me over that. If you do fall within it, it's because you, again, have exercised your First Amendment and they're doing what's called chilling your speech. The chilling of speech goes back to the inception of the statute in 1992 in California, and it all came about because a rich developer near my house wanted to develop all his farmland and turn it into commercial development. And when the neighbors all complained, he thought he would be out tens of millions, if not hundreds of millions of dollars. So he threatened to sue all of them because they blocked his project. And that was the idea of a rich developer beating up on people exercising their rights. So that's the idea of the anti-SLAPP. So now you're sitting here looking at this lawsuit and you're thinking, how can I throw this case out? Well, California Code of Civil Procedure 425.16e gives you 4 different ways. The first one would be that if you made a written or oral statement or any writing in front of a legislative, executive, judicial board, and I'm paraphrasing. So anything that you're being sued over that you had submitted to a government agency to review, or even a pleading that's filed and you're being sued over the fact that you submitted a pleading. Number 2, any written or oral statement or writing made in connection with a matter that's being under review by a legislator. So pending legislation is an example. Anyway, number 3 would be any written or oral statement or writing made in a place open to the public or a public forum in connection with an issue of public interest. So there's some different parts here. Are you in a public forum? Websites are usually designated a public forum. But public interest has many different parameters to that. Just because you're a celebrity, for example, doesn't necessarily make it an issue of public interest. And you can't just make it an issue of public interest simply by broadcasting it to a lot of people. Then the catch-all, E4, any other conduct in furtherance of the exercise of the constitutional right of petition or the constitutional right of free speech in connection with a public issue or an issue of public interest. So there it is. You have to fit within those 4. Normally, it'll be just because of what you said or wrote. That's typically what the anti-SLAPP is about. So let's just focus on that. All right. So you're talking to your attorney, and your attorney says, you know what? I think we've got grounds here to anti-SLAPP. Now, I'm not going to give all the different procedural rules on this. Also, when you anti-SLAPP, you have to do so within 60 days of appearing in the action. Don't blow deadlines. There is an ability to go, you have an ability to go to a judge and ask for an extension of time if you've already blown the deadline. Now comes the actual legal reasoning. If it's a claim of defamation, you can always anti-SLAPP defamation. If it's a claim of false light is one of the stupidest claims you could make in California because it's what we call superfluous of a defamation claim. It adds nothing, and it's basically subsumed into the defamation cause of action. So that's ripe for anti-SLAPP. There are certain types of claims that if you make them, that could trigger an anti-SLAPP. And your lawyer better be cognizant of the fact that there's an anti-SLAPP risk if he sues under certain claims. Now, in order to throw the case out, you have to now prove that no matter what the plaintiff tries to do, the case will fail, that they cannot state a claim against you. Now, to do that, you need to refute it with evidence through declarations and things like that. And you have to look at the elements to the cause of action. For example, if it's defamation, then there'll be a statement. It will be false. Whatever the elements will be for your particular claim. Then you show, for example, that they can't meet all the elements. I like the one where you show that there's an affirmative defense, such as a statute of limitations defense. And with that, no matter, even if they could plead the elements, it's time barred, so they can't win the case. It's not a mechanical thing. There's actually a lot of creativity that goes into this. And also whether or not the attorney you're dealing with is a bozo when it comes to evidence and the rules of evidence. Many attorneys are.
So there you have it. It's a very important area of law. And with some creativity, it can really be applied to a lot of things. But usually it comes down to what you said about somebody or what you wrote. And if you don't have a lawyer that understands anti-SLAPP, you've got to find a different attorney. A highly nuanced field. And I know the lawyers, most of them, at least in Orange County, LA, I know who does this kind of work, because the best lawyers are, they just mow everybody down. Now, just to give you an update, I told you I was hired for, I thought it was $35 million, but I was wrong. It's a $25 million defamation lawsuit. My name doesn't appear on the pleading, even though I was asked to join the case, but I couldn't, I was too busy. It's a case that's actually in the newspapers. We defeated throughout the whole case because of an anti-SLAPP motion that I helped to write. I said I would work on the final draft and do the final edits, and then lead counsel can take it from there. I put in the case law that I knew that would help us win. That whole case was thrown out, a $25 million lawsuit thrown out on its ass. Oh, and you know that big eviction case I was handling downtown? I ultimately lost the case. See, I don't hide from losses, okay? I don't. Now, doesn't happen very often, but it can happen. My clients don't think that I lost the case, and neither do I, because the judge was giving us the win up until the very last moment before everything switched. And it all switched on a technicality that I didn't see really applicable. But the judge was bothered that the money paid for the capital expenditures did not come directly from my client, but from a subtenant who wanted my client, who was the master lessee, to still be liable for. And as a result, we lost on that one ground. They had 9 lawyers teamed up against me. And just for fun, I filed a motion. Now, remember, if you win a case, you get your filing fees, you get your, deposition fees, you get stuff like that as a prevailing party. Not necessarily legal fees unless there's a contract for it. And that's section 1717B of the Civil Code, which deals with prevailing party, and sometimes prevailing party isn't clear. In this instance, they were definitely the prevailing party because they won the case to get my client evicted. Remember, it was an eviction case. Now, I had patterned this defense off of a very interesting application that the judge had never seen before, one of the most senior judges in LA. And I said, look, capital expenditures, we're going to use that to offset the rent, which threw this other law firm in a tizzy. With 9 lawyers and, let me think, 1, 2, 4 or 5 law firms. Okay. I mean, I was battling an armada of attorneys. Anyway, even though the case was over and they won, my clients are still there, by the way. Still haven't been able to throw them out. I saw that in my mind that they went after a writ of possession improperly and violated the code. So I entered the picture and I made them start all over getting a new writ of possession, which obviously meant stopping the process and complying with the law, which of course slows things down because they're not doing it according to what I think is the law. Then I brought another motion to do what's called striking or taxing the costs. So now that they won, there are certain fees they're entitled to, recording fees, process server fees. You get those as the winning party, irrespective of attorneys. But getting back to the motion that I filed to tax or strike costs, turns out they filed it late. I saw that. I jumped all over them. And the judge this morning affirmed his decision because he gave them extra time to try to refute my briefing that said they couldn't claim it. And the judge agreed with me, and he struck all $53,000 in costs. Okay. Now, I want you to think about how big of a case that was when you have $53,000 in costs just on their side. Okay. Anyway, I got that all stricken. I also filed an opposition to hammer the attorney's fees that they're claiming $542,000. And I've really taken a hammer to that. So we'll find out next week how much I've reduced it. Hopefully I've done a lot of damage to that as well. And then, of course, like I said, the most recent win, it came down about a week ago, $25 million case tossed on its ass because of anti-SLAPP. I love it. And hope you guys like the new format. I'm learning how to become more of an editor. Well, it's certainly not something that has any skill, believe me, as I don't have it.